motion for the court of inquiry hearing and other motions. There were other motions that were part of it too. But I was kind of zeroing in on the court of inquiry because I don't know, I was just curious. I don't have a stake in it either way. I mean, um, I don't know much about the case, the underlying criminal case, and Brett Jace's case. Um, I was just curious because, as far as I understood, and I could be incorrect, the threshold for doing a court of inquiry was probable cause. Now, there may be other elements associated with that. I I would love to see the Michael Morton court of inquiry transcript. I just haven't bought it yet because I think it was $1,800 or something like that. Yeah, I was just curious. There's some case law I looked at about what probable cause was. I don't know if there's case law out there that distinguishes between, a criminal officer making an arrest probable cause and court of inquiry. Do we even need to start a court of inquiry? Because the request for a court of inquiry from a district judge, as far as I understand, that I'm sure there's a name. I'm getting the nomenclature a little off, but it starts the process. So just because a district court asks for a court of inquiry to the administrative judge, which the administrative judge is the one that pulls it all together, gets a visiting judge, and if they need, I guess, a special prosecutor or something to investigate the claims and accusations or whatever. So, when they put together the court of inquiry, at that point, it was just probable cause. So I'm looking at the probable cause threshold question. Yeah, it's just kind of interesting to see what the city did, what the district attorney did, and what the district attorney's criminal defense attorneys did in that hearing. That's not to say that there's things that I didn't miss. I'm sure I was looking at it through the court of inquiry filter, more or less. I didn't really care about the underlying criminal case. It's kind of its own separate issue, but I mean, kind of yes and no. But there was sworn affidavits done by a former city manager and a former city council member. There were talks of an alternative suspects theory, and I'm looking at the federal cases about like Brady versus Maryland and Miranda rights. So I don't remember if it was Brady versus Maryland or Miranda where maybe it was Brady versus Maryland, because I have to look up that case again because it had something to do with the evidence that was relevant only applied in the punishment phase. So even if it's evidence that just applies in the punishment phase as far as how to assess punishment, that evidence is material as well, just as much as guilt or innocence phase, because it has an effect on a criminal defendant's rights. As far as I understood, the allegation was that the Travis County District Attorney turned over what they said was everything that needed to be turned over through some type of representation made to a court. I forget the exact name of it. It was basically like some type of filing to the court saying, we have turned over all things material, blah, 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 blah. And then the defense attorney, Doug O'Connell, for Chance Breches, and one other defense, I forget his name. There's another one as well. There's multiple attorneys on defense's side. They're claiming that, well, we have independent knowledge that there was an alternative suspect theory that the state had, and the district attorney's office engaged in negotiations with what was potentially an alternative suspect. And I don't know, it just kind of strikes very close to the Michael Morton story because as far as from a legal perspective, now the actual underlying facts themselves, the specifics of the facts are different, but the legal facts are similar. There's, Ken Anderson only focused on one suspect, but there was evidence of a potential other suspect, such as the bloody bandana or Michael Morton's son. Now, how much weight it had is, that's a fact question. But the theory was or at least what was articulated was, there was his son said that daddy wasn't there when mommy got murdered. He said other things that I forget the exact specifics, but he said things that would lead an investigator or prosecutor to go, it might not have been Michael Morton that killed her. That's the alternative suspect theory, or in a version of it anyways, in a nutshell. That was evidence that should have been turned over to Michael Morton's defense attorney, which was not. It's like, you look at legal documents from the 70s and 80s and the Supreme Court of Texas opinions and appellate opinions, and they're like, prosecutors need to be able to go hard and blah, 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 blah at prosecuting a case, and they don't have to turn over everything to the defense. Well, that has since changed after Michael Morton, because we found out after the fact that there was stuff that state didn't give over. And going back to the Chance Bridge case hearing on a court of inquiry and related motions, they brought in, so the defense brought in 2 affidavits that would support, in theory, probable cause, right? Because the standard for court of inquiry, the burden of proof is probable cause. It is not preponderance of the evidence. It is not clear and convincing. It is not beyond reasonable doubt. It's far below all of that. It's probable cause, which a lot of criminal defendants meet very easily, very quickly. Lots of other cases. It's interesting just how that works out to me. It's like you got thousands of defendants, officers just making a sworn statement on their arrest affidavit or whatever. And it's like, yep, probable cause. We're moving forward. But with the district attorney's office, it's like there's 2 sworn affidavits. Now, their response to that was interesting to me, because they're like, they classical denials. And then they also had their own affidavits that said, well, we looked for something that was hinted at by Mackenzie Kelly's affidavit and Bruce Mills' affidavit, but we didn't find anything. That to me is interesting, because I have seen that before. And I think they were being very careful with the words they were using and how they were using it. It would make it sound like they're lying. We don't know what they're talking about, right? That's kind of the underlying purpose from my perspective. And I'm sure there's other things that the lawyers are thinking about. They're trying to think of, they're trying to help with the liability, I guess you could say, of the city. Now, what liability that is an interesting question as well. What are they worried about? Why are they in there worried about just something a former council member or assistant city manager said? Isn't that interesting? I think that's interesting. That, to me, shows, it doesn't prove it, but it kind of hints at some type of motive going on here that is undisclosed. At this point, it doesn't even involve the city, right? I've seen this movie before. They come up with a very well, carefully crafted affidavit. Devil's in the details of this one. It's like, well, what emails were they talking about? What do those emails show? And what would they infer? Because there's going to be a lot of inference here. It would appear, if what the defense is saying is true, the defense is saying, hey, they're engaging in something where they're intentionally trying to hide it. That would mean that you're going to have a hard time finding something that says, let's mislead the court and do this felony. They're never going to write that down. Well, if they're smart, they'll never write that down. So that you have to look at a pattern of behavior and underlying circumstances and see and infer what is going on off of the facts and circumstances. And then they said, what I think it was really interesting is that the district attorney's office, or defense representing one of, I think maybe it was Garza, saying something about they were trying to downplay the Ring Collective and how they have any part in this, and Jessica Brand. Now, I really don't know how much the Ring Collective played a part in this. My gut would tell me that, well, if there was consultations with the Ring Collective. It's very under the radar, and we'll only find about this years from now. I think their reaction to it tells me something. It's like, we want to keep Jessica Brand out of court. We do not want her answering questions under oath under any circumstance. I just kind of got that vibe. That to me is telling. It's like, well, I get it. Like, there's people out there that say, if there's nothing at high, why are you worried? And that's not always true, but I don't know. Like, I feel a sense of like, there's fear there, right? A fear of testifying and just saying, my name is Jessica Brand, and I just have conversations here and there with the district attorney's office, and that's it. I don't understand how hard that could be, but apparently they don't want to do that. I wonder why. I can only speculate, but why Jessica Brand is a calendar entry. Yeah, they're trying to explain that away. They have innocent explanations for everything, it seems like. State became aware of munition issues. Paper R does not satisfy discovery. What happened when? That's interesting. So they just gave out a newspaper article for... It just seems like they're using every technical roadblock they can instead of just asking the fundamental underlying questions of, well, what part did the city have in this? And they're not going to answer that question. They're going to answer some other question like, well, there's no reason to blah, 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 under the law. Like, they need to provide us with the affidavits so we can review them. Although they clearly can get a hold of them if they need to look at them. So, I got a hold of them. Member of the public. And they're saying, as lawyers, well, we need a copy of the affidavits. Really? Lack of intent, not address, disagreement, no intent, lack of intent, no tampering. Nothing is concealed. Evidence is easily found. Open records request for those documents. We gave those calendars out freely. They're trying to give themselves credit for what the law requires them to give out, which they all... Well, let me give out a secret. Those calendars, they likely came from me. So a lot of people ask for the records that I get a hold of. Reporters, defense attorneys. Doug is one of them. He's like, hey, don't you have calendars? And I was like, yeah, here it is. And I do that with many people. They're open public records. But I will tell you, I know I could be wrong, but I feel like I am one of the people out there that knows best how annoying it is to get records out of the Travis County District Attorney's Office. I don't know every aspect because there's lots of people out there that are trying to get body cam footage. I'm not always trying to get that because that gets expensive fast and you have to provide specific information for that they don't tell you about. They just deny it, which is another thing. But I have asked for things that I know they have, that I've seen from other open records requests, even to other offices, and they don't provide it. Then I ask for it specifically, and then they claim an exception. Or I ask for something else specifically that I know they have. I've seen another email threads, and they're like, oh, no records responsive. And of course, they're going to come up with some ridiculous excuse like, oh, we didn't search it according to some weird term or something. But clearly, they could have found it if they were being honest. So I would just say that I have seen multiple times the district attorney's office play games of open records requests. And for them to try and give themselves credit for them giving out those calendaring entries, which are super public, 552.022 information that they are required by law to give out. Sometimes they have played a little bit of a game trying to give that out, including other super public information, by the way, that I have a new lawsuit that is about. So it is astounding to me how they go in court and they make themselves sound like, we've given everything out freely and voluntarily. You're required by law to give that out, and everything else I asked for, you fight tooth and nail over. Like, I've had a threat to sue you guys over similar super public information, like the amount of money you spent on a prosecution. Why are you trying to hide that? Like your security spending on Jose Garza. Why are you trying to hide that? You could redact out the sensitive parts. Just give the general information that shows how it's spent. And they're just, Jesus. I mean, even the AG told him. It was like, hey, this is established guidance. This is established open records decisions. You can just follow, this is not exempt. And they're like, well, we think it is. And at the end of the day, they gave out more or less what they may not have given them everything, but they gave a lot more than what they wanted to, which was in accordance with open records decisions. Why do I do so many open records requests to the Travis County District Attorney's Office, you might wonder? It's a damn good question. I'll tell you why. When I wanted to understand my criminal justice system, for example, in the courts, I go into the courts and get a hold of the filings. I see the filings. The rules are there. Procedures are there. It's all on their website. And some of the stuff you do have to request, but it's not that hard to request. They get it to you pretty quickly. I went over to the district attorney's office. I couldn't find a thing. Like, there was basic information there. Very basic information. But there wasn't much. It was like under construction or something. They since updated their website. It looks a lot better now. But if you want something on a specific case, unless they've done a press release, you can't find anything on it. So you literally have to do an open records request. And then I started doing open records requests. And they're like, we think this is exempt under 552.01008. And they did that for everything, including like offense reports on stuff that isn't even like in the courts anymore. But it's just really weird when they're handing out offense reports to or case material to reporters, which is discretionary. They can hand it out if they want to, but they can also withhold some of it. And then they withhold. It's just like they're very selective with their transparency in a way that helps them. That's the key thing. Here's a case in point. The Daniel Perry offense report. Oh my God. Oh my God. I have asked for it again and again and again. The city of Austin and then the district attorney requests through the AG ruling process that offense report be redacted or sorry, not even redacted, requests that be withheld completely. And then I requested from the district attorney's office and they try to withhold it as well. It is interesting to see the same thing I've been seeing for years now in that courtroom, that the city and the district attorney sometimes, now who's playing who for what, I don't know. Fast forward a couple of years, I'm finding public documents that show, they might have handed out that offense report already. And then I do some new open records because I think I asked for it at least 2 or 3 times to the district attorney for that same offense report. Maybe I asked for it 2 times from the city of Boston. Every time they're like, except for once, but every time I said, and this was part of the earlier lawsuit too, because it was within the scope of the responsive information. Finally, they give out an earlier version of that offense report, because there are multiple versions as I have come to find out through, I'm not going to disclose publicly how I know, but they gave it out in like 2021 or 2022. Well before I asked for it. I asked for it. And they said they can't give it out. But there's already a government code in Chapter 552 that says even if it's discretionarily exempt, if you've given it out before to someone, you have to give it out to everyone else who asked for it. There's also a uniformity clause in Government Code Chapter 552. So it blows my mind. They're caught on paper saying, I asked for it multiple times, and they're like, that's exempt. We can't give that to you. I'm getting closer. They can tell I might have some information, and I'm like, I asked for it again, and they finally give it to me, and they show that they've given it out to a prosecutor in the U.S. military. Why they didn't use a more formal legal process, I don't know. But the process they used was Government Code Chapter 552, and they gave it out under Government Code Chapter 552 before I even asked for it. And then they said, we can't give that to you. As I've come to find out, that was a lie. That was a straight up lie. And it wasn't like one person looked at it. They could not claim that, because in order to ask for an AG ruling, they go to the city of Austin. That's the second pair of eyes looking at that. And you know who files the actual AG ruling? The county attorney. That's a third pair of eyes looking at that. So this idea that, yeah, how long do you have to wait until you realize they're playing people? They'll even play a judge. It doesn't bother them. They will do that. And guess what? By the time judges often find out, it's too late. They've been played. And I guess that's why it's so frustrating, because I've seen this process on paper. They just use it in different ways.